Hello, Cooterville. Everybody, welcome back and welcome in. Thanks for joining me this morning. It's good to see you guys. I've missed you. I've missed you. So, before we begin and we get into today's stream, there is something that I'd like to say. I would like to address for some of you. You have seen years old clip, a years old text, like really old stuff circulating about me recently. And I want you guys to know that that does not reflect who I am now. I don't speak that way. I don't think that way. And I've grown from then. I'm not feeding the person that posted these things because their goal is attention, not accountability. And that is that. I hope that y'all will still enjoy my content. And I would like to welcome you guys in. Thank you, Stay Humble and Tara, for your super chats. Thank you, Sophia, for gifting 1 and Flo for gifting 5. Thank you so much, so much. Who is the late? Salty. Thank you, Salty, for your super sticker. It's good to see you guys. Oh, thank you, Pines. I got these on Temu, and they're cute as shit. I hate to admit that, but I did order off Temu. Hello, Snazzy. Hello, Keezy. Hello, St. Elmo's Fire. Good to see you guys. Hi, Kira. I literally love when people grow and evolve. The people who matter will love you for who you are now in this moment and all your moments. Thank you, Kira. I mean, it's pretty wild. Hi, Penny. Good morning. Hi, Kate. It's just really wild because now you got people saying they want to strip me of my plaque. But yeah, I mean, if you haven't seen anything, it is what it is. But I just wanted to address, I didn't want to act like it didn't exist. There's very few people, I think, from that sector that watch me, but I just feel like it's fair. When you order off Temu, you're undercutting Walmart. Purple Passion. Aw, Kelly Mack, thank you. I appreciate that. Good morning, Christy. Like 8 St. Elmo's or something like that. Okay, so this is what we're going to do today. So I've got a lot on our agenda. So we're going to jump right into it because I'm learning along with you guys because I've been sued in copyright court. Hey, fam, good to see you. Cutesies. Hey, cutesies, will you send a message to Molly and tell her thank you? She'll know. Thanks, coconuts. Hey, sips of coffee. Speaking of sips of coffee, let's all take a sip of our coffee and get ourselves together this morning. Did I win what? Isla Bear. Thank you. What did I win? I don't think I've won shit. Coconuts, your picture is so cute. Slurp. So what we're going to do today is we're going to walk through because I've been sued in copyright court, like federal copyright court. But this is a new thing. They have the United States Copyright Claims Board. Oh no, I did not. I lost. I was sued by you guys are probably fairly new to me. Some of you. I was sued back in 2022 over the Brian Laundrie case and some footage from what are they called again? WFLA. They said that I was a threat to their Florida market and all this stuff. And then the lawsuit started out with I think it was at least $1 million they were wanting. And then at the very end of it all, I owed them $5,000. So it was wild. Thank you, Kate. I think it's for attention. It's definitely not to hold me accountable. That is stuff too that came out years ago. And it's just messy. The one and only Molly Golightly, yes. So yeah, I went through this whole thing for like years. And in federal copyright court, you have to have a lawyer. So I like Nunya, I like was responding pro se because I couldn't afford a copyright lawyer. The cheapest copyright lawyer was $500 an hour, and they would have had to review every stream. And my streams were 8+ hours during the Brian Laundrie manhunt. Hey, True Psych Ward. Dude, it was a wild time. Dr. B. Dr. B making a comeback. I mean, it kind of was kind of Kelly Mac, like a little bit of a, like, wow. But if you think about $500 an hour, and then they got to review all the streams to even see, hey, do you even have a case? Could you even win? Hi, Donna. Oh my God, Hot Ham Radio. Hot Ham, I saw you in Hella's last night. Did you guys see Hella's last night? Hella showed the other view of the Boise incident. And I've got a sneak peek for you guys today because I was sent that same footage. We're going to put that side by side with the original footage, and then we're going to put it next to the new. So we're going to have both views at once. Yes. So go check out Hella. She played it last night. And I saw Hot Ham in the chat, and I was like, oh, Hot Ham, I haven't seen you in forever. Hot Ham Radio, my oldest son, is now doing Hot Ham, is now a ham operator. He got his license and everything. And are you still doing Hot Ham Radio? Suzanne, thank you for your super chat. I've said shit in the past. Just leave that shit in the past and move on. Thank you, Suzanne. Hot Ham Radio, I'm back for the HTC stuff, she says. Hot Ham Radio. I've always loved that name. And for some reason, way back when, I always thought you were Crafton Barnes under an alt. I don't know why. But I'm glad to see you. You're too busy momming for hamming. Yeah, he was talking to somebody in Jamaica, like right before the hurricane, like when the storms were coming in, the hurricane. I heard that Kresha emailed Turtle Boy back. They're going live today, or are they recording? Do you guys know? Hey, single mom of 3. No, he's not making money. I don't think. It's a hobby. I thought it would be cool if he streamed some of his stuff, but I thought that would be pretty cool. Hey, Vogue Mod. Yeah, that'll be a good one, huh? I always thought gray pubes had something to do with that. I remember him nonstop complaining about you playing the news. Oh. Yeah, I don't know who turned me in for that, but somebody definitely brought me to their attention for that copyright. So he usually only streams live. That's going to be great. So this is a new thing. The United States Copyright Claims Board is kind of like a small claims. It's like a small claims for copyright. He is an absolute asshole. He's been an asshole ever since I've known him on here. And he was one of the first people I met. Molly Golightly and Gray Hughes both popped up on a panel I was on when I first came to YouTube, when lives first started. So pretty wild stuff. Idiot. Thank you, Idiot Wind. I'm not part of anyone's hive mind being controlled by some queens perfectly capable.
I'm not part of anyone's hive mind being controlled by
Preach it.
some queens. Perfectly capable of what's important for myself, evaluating where I think there's unfair treatment.
Thank you, idiot. Wind. Thank you so much for your support. That's really generous of you. Yeah, Kresha, actually, I saw that she put in Hella's chat last night that Kresha actually got a text from Tricia at Web Sleuths yesterday. And Tricia at Web Sleuths texted her about something she said in her November 14th live, which I listened to this morning. Hi, Sarah. She texted her about her November 14th live and said, you said that I shared autopsy pictures behind a paywall and you were incorrect in stating that and demanding she correct it and all of this stuff. And I went back and I listened to it, and it wasn't even Kresha that said it. It was Jewels of Thought was on her panel, or they were dual streaming or something. It was Jules that said Web Sleuths did it. It wasn't even Kresha. It was Jules. So Trisha just keeps texting Kresha. Oh, Grayson didn't do that. Don't say that about Grayson. Like, stop it. Why do they think they can text Kresha like this? That's a question. That's a question of the day. Hey, Michelle, why do you think they feel comfortable doing that? I mean, obviously, Trisha felt comfortable enough to do that to John Ramsey at CrimeCon, so should we really be surprised? Jay and Sav were the first lives I ever chatted in. That's awesome, Wicked. Kresha needs to block her. They're trying to intimidate her. Yeah. Why would they want to do that? It's just so wrong. No boundaries. Yep. Kresha's definitely got an army behind her. Turtle Boy wanted to know why they're not suing him. Sips of Coffee says they feel threatened by her, so they bully. Hey, security. Good morning. Oh, really? I actually enjoyed Jewels of Thought and Kresha's discussion. Did you guys listen to it? If you go to Kresha's channel, it's from November 14th. I don't remember what the title was right now, but it's her and Jewels of Thought, and they really had a nice conversation about, I really learned a lot from Kresha about how this has affected her family. Just the more I listen to Kresha's experience, I feel like the more that I understand how these victims aren't just, shiny little toys for everyone to gather around and want to grasp onto. It's not cool at all. And
help a brother out here.
The Idaho case kind of gave me like a little different thoughts on how true crime I want to cover it. And now this has a whole different level of victimization and learning what really hurts them. What, like you've got the Gonsalves family with supporting a petition to stop the filming of the Lifetime movie. But unfortunately, it seems like whenever there's money involved, welcome back, Fem. Thank you for rejoining.
She says, welcome to Cooperville. Everybody close your legs. Everybody coming in, close your legs.
Close your legs.
And whenever there's money over anything, like feelings aren't going to account. You know what I mean? Fem, your new picture is really beautiful. I knew you were pretty, but damn, girl. Tara Lee, yeah, that it is. You got to stand up against that mob mentality. You guys are individuals. This is your time spent. This is your choice. And I appreciate you when you're here with me, like right now. But I don't own you. I don't own the kind of content you watch. I don't own the creators you watch. I don't want that. I just want to enjoy when you're here in my channel and in my chat because I love you guys. I love the conversations that we have. I love your humor. I love all of that. And I would never want to lose that. So let's get into today's stream. This is going to be like a learning stream a little bit. And we're going to go over what Lauren filed with the Copyright Claims Board, not only against Kresha, but against, hey Becky, against Sleuthie Goosey. And there's one other person who was reported by Lauren. But this is taking it to the legal level just on a small claims level, not a federal court level. So I'm going to turn my camera off and move this so it's bigger. Let's do this. This is wild. So remember how I actually might turn off the chat for this. Let's do this because I want you guys to be able to see it. So this is almost as petty as the whatchamacallit, the RO. So let's take a read here. So we've got, this is from the Copyright Claims Board, United States Copyright Claims Board. It's also known as the CCB. And it says, type a claim for infringement. Would you like to proceed as a, quote, smaller claims proceeding, including the $5,000 monetary limit? So clearly this isn't about a large sum of money like mine was in federal court. They were like millions. In federal court, it's $150,000 per infringement. And I'm not looking at chat right now, so I'm not trying to be rude, but I'm trying to focus on this, and I don't want to say anything wrong. So there's a $5,000 monetary limit instead of the standard CCB small claims proceeding. So I think you can go up to, I don't even know, like 60 grand or something on here. But Lauren's not filing that. She says, yes, I'll keep it at the lower level. And it says claimant, Lauren Matthias, down here at the bottom. So we're going to go up here and it says YouTube channel, difficult research, which is Kresha, channel owner Kresha K. Describe the infringement. Kresha K, also known as difficult research on YouTube, played our entire video on her YouTube channel. She took our content, which we wrote, directed, and produced entirely on our own from our YouTube channel, Hidden True Crime, and then played it on her own channel. Now, never mind that the photos were Kresha's family's photos, right? It is identical to ours, except she talked out loud while streaming our video. So she could claim it was, quote, commentary, end quote. When in fact it was not commentary and certainly not educational. Yes, it was commentary. They were talking about what was happening with their family while rolling the footage of you with their family. It was completely relevant commentary. As a matter of fact, it was two victims telling their story. It was two victims telling their story about you while playing your video that they were in. And their family's pictures are in.
The law and crime.
Now, if Kresha would have just rolled Lauren's video, audio and all, and didn't do anything, then yes, that is not fair use. But what she did is more than fair use. Now, that's the beauty of this, Trish. That's the beauty of this, Trish Norman. You don't need a lawyer for this. So this is not like federal copyright, okay? So Lauren represents herself and Kresha represents herself. And I'm here for it because Kresha hasn't done anything wrong. Kresha has quite the story to tell. And Kresha is a very, very strong individual. And Kresha also has tons of people behind her and supporting her. So I think this is, 100% petty. I don't think she has a case to stand on. It's wild that she would even do this. So let's keep going. And who is she to say it wasn't educational, right? Like, who are you to claim it wasn't educational? I think that anybody who listened to that stream would beg to differ, because anytime you're learning new facts about something, it's educational, right? I mean,
wake up.
Wake up, Lauren. Anytime you learn something that you didn't know before, it's educational. We didn't know Kresha and Kay's stories before. Therefore, educational. A lot of us found it very educational. Yes, absolutely. So I think that if a judge actually listened to this, they would also learn something from it. Are there any respondents, online service providers? No. Okay, now, definition of harm suffered and relief sought. I did start early, Zuzu. I have been going to bed so early. I went to bed at like 9 last night. And I'm up at the ass crack. Like, I'm up before the sun comes up. I'm all on a weird schedule. So I apologize. Okay, so the description of harm suffered and relief sought. The harm is that viewers were not watching the video on our channel. Huh? If they watched the video on your channel, Lauren, they would have got a different message. Because Kresha was commentating over it. So anytime you have a copyright issue, the whole thing is transformation. The whole basis of fair use is transformation and education and commentary, criticism, things like that. But transformation is number one. If you review a video and that person who's watching you walks away with a different take, a different idea, a different viewpoint, and things like that, then you have transformed the content. If they leave with a different message, something like that. So this is federal, Pines. It's just like a small claims, and we're going to get into that. We're going to learn about the Copyright Claims Board. You know how I am. I'm going to show you all. We're just going to read this first so you get an idea of what the filing looks like before we watch how the process works. Okay, so just bear with me. The harm is that viewers were not watching the video on our channel. Rather, they were watching the video on the Difficult Research channel instead. Not only was the Difficult Research channel stealing our work, Kresha, using her Difficult Research channel, was also encouraging hatred and spouting harmful and false narratives about hidden true crime. honey, this is not a copyright issue. Copyright has nothing to do with what you think is hatred or someone spouting anything. Okay? That's not what copyright is, Walwyn. No, it's not, Walwyn. Nope. But see, she's got to do this, and she's going to end up
on prime crime
if she keeps doing this shit. Because nothing about copyright is about false narratives or harmful or hatred shit. None of it. That would be defamation. Again, she's doing something when she really should be doing defamation, right? She did the RO when it was all about hurt fifis. Now she's doing this and saying, oh, it was also encouraging hatred and spouting harmful and false narratives. Like, shut up. All right, so let's go back up here. Infringement claim. Works infringed. Now, this is where it gets ironic AF. Title of work. Larry Woodcock breaks down over J.J. Vallow's murder. An interview with Kay and Larry Woodcock. The fact that she would even be so tone deaf to even file anything with that title is beyond fucking me. I'm floored. I mean, I'm literally floored.
What?
She's suing this family when the title of the work is Larry Woodcock breaks down over J.J. Vallow's murder. An interview with Kay and Larry Woodcock. Meanwhile, this is a video of Kay telling her story and her experience with Lauren, right? Showing photos that Kay graciously gave to Lauren for her work. I'd like to know if they signed any kind of release, because really, in her video, she should be giving credit to the Woodcocks for those photos, not suing Kay's daughter for talking over their own photos. This is insane, right? Hey, Amy Lynn, good to see you. Chi-Chi, welcome in. And Yaya. Chi-Chi and Yaya. I feel like I'm on an episode of the Teletubbies. All right. So that's that. Author, Lauren Matthias. Has the work been registered by the Copyright Office? No. So that, I don't know if that's a prerequisite for filing one of these. Because in federal copyright court, you have to register the works before you can file. So WFLA went through and they took the works to the federal copyright office. They registered them and then they sued. Now, I don't know what the agreement was with this, Yaya. I don't think that maybe since Lauren didn't have like NDAs for things, that she probably didn't have a contract. I can't speak for that, though. Only Kay or Kresha could answer that. I don't know if there was any kind of a signed deal, giving these pictures over. I don't know. But we'll figure that out as we find out how this copyright claims board works. So we have a service request number and then type of work, motion picture, and audio visual. Describe the work. Audio, video. Now see, she says audio, video interview entirely produced by Lauren Matthias, Hidden True Crime. Infringement claim, wrongful activities are publicly perform the work. I don't even know what that means. Publicly perform the work. Okay. Okay, so then this, I went out of order. So down here, she says she was spouting harmful and false narratives about Hidden True Crime and Lauren Matthias. This led to many online narratives and posts being created about Hidden True Crime that were simply untrue. So now she's blaming Kresha for online narratives and posts created about her. Oh my God. Hey, does this lady ever take accountability? I really need to know. I really, really need to know. She says the relief we are seeking is that the streams of our video interview not be posted on the internet again. What? How about her being responsible for the narratives and posts? I mean, what the fuck? How do you do a 9-hour live and then expect people not to fucking talk about it? This is crazy, right? So then you have down here, it's the Larry Woodcock breaks down over J.J. Vello's murder, an interview with Kay and Larry Woodcock. It's the file of the MP4, the original copyright takedown request, the response from YouTube showing the video taken down, and the thumbnail for the original video. And then she's got her email. Is that not some wild shit? I know, Laura Taylor. It's crazy, right? Okay, so now we're going to go over to this. Let me get our chat back on. And we're going to learn about this copyright claims board. This lady is like the head of it. So this is going to tell us how it works. So here we go.
Alternatives in Small Claims Act, which is a bit of a mouthful, so we just call it the CASE Act. And the CASE Act asked the Copyright Office to put together the Copyright Claims Board, which is a first of its kind small claims IP tribunal in the United States. And the idea is that it is less expensive, more time efficient, and accessible to everybody. It can be accessed virtually.
And when you say less expensive, how much does it cost? Let's say I feel like, somebody feels like they have an infringement against their copyright. What's the process?
So what the process is, and again, as I said, it's all virtual. You can do this all from home. You never have to leave your home to protect your copyright. And what it is it's a $40 fee to file a claim with the Copyright Claims Board. The attorneys at the Claims Board go through and check to make sure it's a compliant claim, because there are only certain claims that the Claims Board can hear. It's damages for $30,000 or less.
Okay. So when you file a thing, there's lawyers that look at them to see if there's even a valid claim. So I can't speak for Kresha, and I haven't seen her here today. So I'm not sure if she was actually served with anything or if someone just found that Lauren had filed this. I'm not sure how that all went down. So yeah, now this is accessible to anybody, Idiot Wind. And it's like $40 to file. It's crazy, right?
And check to make sure it's a compliant claim, because there are only certain claims that the Claims Board can hear. It's damages for $30,000 or less.
Okay, so I misspoke. It wasn't 60. It's 30 or less. And then the lower level is $5,000 or less.
And particular types of claims, for example, an infringement claim or looking for a declaration of non-infringement. And then one other claim related to types of online notices. But what happens is you pay $40 to file your claim. It is a totally voluntary program, so that what happens is after your claim is deemed compliant and you serve it on the respondent, the person you claim is, for example, in this example, infringing, if they agree to move forward with the claim, you pay another $60 and then that's it.
Which brings it to $100.
Yes.
A whole lot less than going to federal court.
Yeah, I would say. Right. I wonder how many claims they get a day. For real. For it to only be $40.
A whole lot less.
So who hears the claims? Like, how is that set up?
So under the CASE Act, there are 3 copyright claims officers. And they are 3 lawyers who are very experienced in copyright, including one lawyer who has a background in alternative dispute resolution or mediations, ways to find, parties to come together to resolve their claims. And the three of them will hear the claim, and then they work together to come up with a decision.
So I know that this is still early. It's just been in July, but how many claims have been filed so far?
So far we have over 150 claims filed, which is wonderful.
Now, this was 2 years ago, though. This shit started 2 years ago.
Now, because of the process of going through and ensuring that a claim is compliant and then having it served, we don't yet know how many of those will end up being active cases.
And give me an idea.
Okay, so do we know if Kresha was actually served? Because this might not be an active case just yet.
Of the timeline. I know that, it's still early, but about how long from the point somebody files to the point that they have a resolution?
That is going to vary a lot depending on the claim and depending on, let's assume someone files a claim and is completely compliant from day one. So it comes in, it takes a number of weeks for the attorneys in the Copyright Claims Board to go through and process the claim and review it, and then they find it compliant.
Okay, so if we go back to this, hold on a second, guys. If we go back to this really quick, this says docket number, new docket, file date 11/11 at 7:14 p.m. Eastern. So if it takes a couple weeks, which I'm sure a couple years later, it's probably more bogged down. So I would assume this is just the filing, because look, it says filing receipt. I don't think Kresha's been served. So they may not even find this as an actual claim. You know what I'm saying?
They will let the claimant know that they can go ahead and serve the respondent. And they will have a couple of months to actually get that done. And then the respondent, once they are served, has approximately 60 days to decide whether they're going to stay in the proceeding or opt out. Because again, as I said, it is voluntary. Someone can still go to federal court if they prefer to have their dispute heard there.
All right.
Okay, so
Making it happen. I want to say thank you.
it looks like in this you defend yourself.
Thank you.
Cheyenne, thank you for your super chat. Cheyenne says Kresha cannot afford this. The holidays are right around the corner. And no, I don't believe she's been served. Thank you. My recollection is that Kresha was notified via email by YouTube that there was a case being filed. Okay. So she probably has not been served. Thank you again, Cheyenne. They've lost around 8,000 followers. Wow. So here is another stream here. This is actually, hold on.
We're using. So I'm going to call on Tom at first here in sort of like a speed dating type approach to ask him to explain very quickly some of these terms. So Tom, first, let's discuss how we refer to the parties in a CCB case. So who is a claimant?
So CCB is Copyright Claims Board.
Who is a respondent? Who is a counterclaimant?
Absolutely. So the text and the rules and the law have definitions for all of these people, but let's just break it down to who they are. The claimant is the person who initiates the proceedings,
which is Lauren,
in front of the CCB, and the respondent is the person against whom the proceedings are brought. Right now. There are certain types of claims that the claimant can bring, and I think we'll talk about what those are a little bit later. But you can imagine that if you are the creator bringing a claim of copyright infringement, then you would serve the respondent. The respondent can, in their response, become a counterclaimant. And at that point, they then have received the information of the claim, and they are going to make a permissible counterclaim.
Hey, creative.
Now, when I say things like permissible, all of these things are going to be outlined in the materials, both put out by the Copyright Office and Copyright Alliance and ASMP, a little plug in there.
Well, what I noticed in this filing is I don't see that Lauren has attached Kresha's video. So I'm not sure how they can even compare. You guys, look at this. For real, look. She attached her evidence. All she attached was her original video, which is the MP4. Para-woman radio. Everybody's parasailing into Everyday with Jay. Cooterville. Para-woman radio. Thank you for sending your people over. I appreciate that. Thank you so much. You guys, if you aren't familiar with Para-woman radio, she has also done some amazing hidden true crime coverage and says it like it is. Go check her out. She does morning streams. I love that. I love that, Pines. Thank you so much, Para. But if you look at what she attached, she didn't attach Kresha's video. So wouldn't they need that to compare? She puts her video, the takedown request, the response from YouTube showing it was taken down, and the thumbnail for the original video. But she doesn't attach Kresha's video. Hey, Dr. Vonda, how are these lawyers going to review hers versus the one she's claiming is the infringing video? Where's the infringing video, Walwyn? I don't see it attached. So how can they even determine it? I agree with that, love always. Good morning, Carolina. Good to see you this morning. I mean, they got to have something to look at. I mean, what the fuck? They're just going to believe her because she's Walwyn. I mean, come on. Oh, Jesus. Okay, let's go back to this guy.
The one other subject I wanted to broach here is the statute of limitations.
Hi, Queen Olive.
So in general, in copyright law in general, you have 3 years after the claim accrues, and that's the time period to bring your claim in front of the Copyright Claims Board. Now, there is a section in the law about tolling, which is tolling means stopping the clock on the statute of limitations claim during the period that the claim is in front of the Copyright Claims Board. There's some rules about that that we probably won't get to go into today. But when we talk about statute of limitations, I want you to really be thinking about that 3-year time frame from when the claim accrues.
All right, thanks, Tom. David, back to you. Let's talk about the type of claims that can be brought before the CC, but also what type of claims cannot be brought before the CC.
Oh, this ought to be interesting. Lauren, listen up.
Oh, I think you're on mute again.
How long ago?
Sorry, 3 types of claims can come before the board. First of all, a claim for copyright infringement. That's a pretty simple one to understand, I think. Second, a claim seeking a declaration that you have not infringed a copyright. So if Keith is about to release a book and Terica has asserted that that book infringes her copyright, Keith, who might be a little bit worried about releasing that book in the face of an infringement for copyright, can come to us and ask for us to rule that no, he did not infringe it. And there are all sorts of circumstances where that might actually be a very useful tool for someone who's been accused of copyright. So one thing I want to make clear is the CCB is not just for copyright owners. It's not just for people who have a claim of infringement. It's for everyone. And we hope we find people coming from all sides of the issues to get rulings from us. Finally, you can get a claim for misrepresentation in a takedown notice or counter notification under the DMCA. Some of you may not know what that is, and it's sort of a detailed thing, but basically, you can send a takedown notice to certain online platforms like YouTube or Facebook.
Okay, and that's what she did. She sent a takedown.
Who have posted material, or rather are making available material that's been posted by their users. And if you send a takedown notice, their law gives them all sorts of incentives to take it down. On the other hand, the person who posted it may not agree and may send them a counter notification, and the law gives them all sorts of incentives then to put it back up. Because of that, the law also provides that if someone makes a representation in either one of those takedown notices or one of those counter notifications, then the person who is at the, not at the receiving end, but the person who suffered because of that, if you took my material, had my material taken down because you claimed it was infringing and it wasn't, and it was because I made you made misrepresentations, I might be able to get a claim for damages against you for the harm caused by that.
Oh, damn. You hear that? You hear that? if you file a claim against someone and it was not, that kresha could get damages. Listen,
if you took my material, had my material taken down because you claimed it was infringing and it wasn't, and it was because I made you made misrepresentations, I might be able to get a claim for damages against you for the harm caused by that. That's a Section 512F misrepresentation claim.
Woo! Pass that on to Miss Kresha. 512F misrepresentation claim, because she damn sure did not infringe on Walwyn's copyright. Not at all.
Those are the 3 kinds of claims you can bring, and that's it. And what can't you bring? Anything else.
Yeah, anything else. What can't you bring? Anything else, such as, quote from Lauren in the filing, Difficult Research Channel was also encouraging hatred and spouting harmful and false narratives about hidden true crime and Lauren Matthias. This led to many online narratives and posts being created about hidden true crime that were simply untrue. Nope, that's not part of the claims you can file, bitch. Listen to that again.
Against you for the harm caused by that. That's a Section 512F misrepresentation claim. Those are the 3 kinds of claims you can bring, and that's it. And what can't you bring? Anything else.
What can't you bring? Anything else.
No, that's exactly right. If you didn't hear David list those a claim, like if you have an ownership dispute, for instance, that's what was on the list that David mentioned. You can't bring those type of claims before the CCB. So
there you go. Can't bring those type of claims before the CCB. She's trying to keep their opinions off the internet. She's trying to keep their opinions of her off the internet, just like she did to Christina. It's horrible.
And next question either for David or Whitney, whoever wants to jump in. Are there limitations as to who can be sued by a claimant that potential claimants should be aware of? Maybe there's certain people they can't bring before the CCB?
Yes, the statute does have certain limitations. First, you can't sue the federal government. You can sue them in the Court of Federal Claims if that's where all claims against the federal government are brought. You can't sue a state, and as many of you know, it's pretty darn hard to sue a state in court as well. We're no better forum for that, I'm afraid. You absolutely can't sue a state before the claims board. You can't sue someone who resides outside the United States unless they have sued you and you're asserting a counterclaim against.
Okay, so it's only in the U.S.
against them. So if someone from outside the United States asked for a declaration that they were not infringing your work, you could assert a counterclaim against them for infringement of that work. But as a general proposition, you can't sue someone from outside the United States. Then there are some other people who can't be sued under certain circumstances. Libraries and archives got a special provision in the Case Act, which says that a library or archive can submit a blanket opt-out, basically, and they've already started doing so. Basically, they file a piece of paper that says, I'm opting out of the Case Act, so don't bother suing me. I'm never going to come. I'm never going to show up, and I don't have to. That's in contrast to what anyone else would have to do, which is once you've been served with a claim, you can file an individual opt-out in that case. So if you're going to file a suit against a library or archive, please check the opt-out list, because if they're on it, then in most cases, you're not going to get very far. And finally, if you're suing an online platform like YouTube or Facebook, based on the fact that they're making available materials that a user posted online, you can bring a claim against them, but only if you have already served them with a takedown notice and they've not complied with it, or a counter notification they haven't complied with it.
All right, thanks, David. And I want to point out before I go on, I noticed that Nora is from the Copyright Office is providing some very helpful kind of additional information, additional resources to supplement the responses of the panelists. So I encourage you to take a look at that in the chat as well while we're talking here. So thank you very much for doing that, Nora. Whitney.
I agree, Brenda
Smith.
Now.
So someone wants to file a claim. What needs to be included in or with a claim that is filed with the CCB?
Yeah, absolutely. So a claim needs all the basic facts of the dispute that would allow a respondent to consider whether or not to participate or opt out. So we need to know, this is a general overview. I know Nora's going to drop in the chat all the details that you need to get your claim ready. But the type of claim that you're going to file. So what category that David mentioned applies to your dispute.
Speaking of First Amendment, I got an email yesterday threatening me that I might be the subject of a First Amendment lawsuit. That was an interesting email. Sure was.
You are, who the respondents are, how to get in touch with everybody. We're going to be communicating back and forth. We need to make sure we have contact information. The fundamentals of the copyright protected work involved in a dispute. So that is what type of work is it? Is it registered or not? How many owners are there?
Is it registered or not? Which Lawrence said no.
Who's the claimant? And the where, the when, the how of the dispute, who took what action, where, what time, to the extent known. We know that, a lot of people are just kind of gathering information and they are in the best situation that they find themselves. We're not asking for perfection, but we do need to have the information sufficient that, we can have clear the claim. I'll talk about that in a moment. Clear the claim, have the claimant serve the respondent, and have the respondent be in a position that they can weigh whether or not they'd like to participate in the CCB proceeding. Oh,
okay. So the respondent has a choice of whether, it is she registered it, Yaya? Really? Because she said in her form she didn't. Yes, it came from a Proton email.
The law and crime.
I will also mention, we do ask for claimants to provide what they want the CCB to do. So for an infringement or misrepresentation claim, that would be awards, damages. For the non-infringement claim, a declaration that the use is non-infringing. We'll also ask for some important documents, things like the work, websites, communications. That's optional at the initiation of the claim point. We'll take care of that if the proceeding goes active. But know that that's something that you can get in place early on when you first file your claim.
All right, thank you, Whitney. I'm going to ask you a follow-up question here. So a claimant submits a claim to the CCB. The copyright claims attorney, like yourself, needs to review and approve that claim. What does that process entail? What happens if the claimant doesn't get it right the first time? Do they have a chance to fix it?
Okay, this
is
a good question.
Right, and how many opportunities do they get?
Yeah, thank you. So yes, the copyright claims attorney reviews every claim that comes into the CCB for compliance. So what does compliance mean? Compliance means that the information that we have matches the requirements of the law, and it matches the requirements of our regulations, and that it makes a claim, essentially. Again, we're looking at how do we put the respondent in a position to determine whether or not to participate or opt out. If the claim is compliant, we clear it for service, and the claimant has the ability to go and serve the respondent. If it's not compliant, there are multiple opportunities for the claimant to go back and fix the issues that the copyright claims attorney has identified. The claimant has two chances, really. Each time the copyright claims attorney issues an order of noncompliance, identifying the elements that need to be fixed, and there will be 30 days for the claimant to file an amended claim. So we got that first chance to fix it. Comes back, we do another compliance review. If it's compliant, great, serve. If not, you get another chance. You get that other chance. Again, you get another order of noncompliance, elements that still need to be fixed. 30 days, get it back. The claimant said with the claimant. If it's compliant, great, serve. At that point, if it's not compliant, at that point, we take it to the copyright claims officers who review it, confirm that there's continuing noncompliance with the law and regulations, and then we have to dismiss the claim without prejudice. I'll note that when we say, you'll hear maybe terms saying without prejudice, with prejudice. Essentially, when something is dismissed without prejudice, it means that it may be refiled again before the CCB, but keep in mind.
Okay, so basically, she has time even if she screws up. Oh, thank you, Dr. Vonda. Thank you. This is so helpful. I hope so. I hope you guys are learning from this because I am too. Thank you, Dr. Vonda. What is a Proton email? It's just a secure email site. But Lauren was all scared of it because she acted like it was, like a hacker email, but it's not. It's just like Gmail, but more secure. Yeah, and that's the thing, St. Elmo's. I don't know if they had some kind of an agreement. But in the grand scheme of things, even if they did have an agreement, there's still the fair use, right? So even if she registered it and it was her copyrighted stuff, you can still play it with fair use. So, all right, let's listen to this for a few more minutes. And then I've got Sleuthie's filing, which is basically copied and pasted.
If you want to refile a claim that has been found non-compliant, you want to make sure that you get it square with the law and the regulations before trying again.
All right, thanks, Whitney. Terrica, let's talk about registration, right? Copyright registration is always a big part of enforcing your copyright and a big part of the copyright system. So does the work that's at issue in the claim, does it need to be registered with the Copyright Office before the claimant files a claim? And what should the claimant do if they haven't registered yet and they want to file a claim?
Those are great questions. So in order to file a claim for copyright infringement specifically before the CCB, the claimant must first file a registration application with the Copyright Office for the works at issue.
Okay. So she had to do that. She put no in this. If you go back to this, it says here, where is it? Right here. Has the work been registered by the Copyright Office? She says no. Ishi, thank you for gifting 5. AKA the Cat Lady, Steph J, Crafty, Adair. Who else? I missed one. Maria. Welcome to Cooterville. Thank you, Ishi. Come on in and close your legs. But yeah, she says no. So they would have probably come back and told her she had to do that, I would imagine.
Only file a claim for infringement if you have a pending registration application on file with the Copyright Office, or the Copyright Office has already approved the registration application and granted a registration certificate. So if someone wants to bring an infringement claim but hasn't yet registered their work with the Copyright Office, they can go ahead and submit a registration application as soon as possible. And once they do that, they'll be able to file their claim with the CCB. Now, the caveat there is that the CCB judges will not be able to issue a final decision in the case until the registration is approved and a registration certificate has been granted. So if a claimant wants to speed that process up, they can pay to have their registration application expedited, and the office will do its best job to complete the review of the registration application within 10 business days.
Now, I feel like if they really wanted to, they could probably get a lawyer to make Lauren take all their shit down that has their stuff in it. I just think that the victims would have more rights at the end of the day than Wolwin. I mean, even if they did give pictures, you know, they were in a very emotional state where they probably weren't thinking clear either. I mean, you can tell by their stories that there's hindsight in what happened and what, you know, what they agreed to in that vulnerable moment. Right. Love always. I don't know. Someone said she might have picked him up from Facebook, which would be really effed up.
In order to expedite a registration application, the claimant needs to submit a request to the CCB and pay the filing fee, which is $50. But one important thing to keep in mind about this is that the claimant can only request an expedited registration after the claim becomes active. So in other words, they have to first give the respondent the full 60 days to opt out. If the respondent does not opt out, the case becomes active, and then the claimant can request the expedited registration.
Okay, so after someone is served, then there's 60 days. So 2 months. That's what the Taylor Swift lawsuit was about, right? So it seems shady for that to be allowed, but I'm just not sure of what current state of law. So I think what the difference is with this is that this is like the small claims of copyright.
All right, thanks, Erica. So Tom, I'm going to call on you to kind of segue us to the next part of the CCB process. So the claim has been approved by the copyright claims attorney. Then what does the claimant do? Like, what's the next step? How does the claimant notify the respondent that, hey, I've got a claim against you, right? And presumably it's some type of notice. And so what are the elements of a proper notice to the respondent?
Yeah. So once it's been approved, once you're ready to notify the other side, the claim is compliant. You have 90 days to serve the claim, and you're going to hear term service. And there's really 2 types of service that I want to discuss. One is with serving individuals, right? The rules that govern process of service can vary from state to state. This is another place where the CCB handbook and all the additional materials are going to be incredibly helpful for you to determine how to serve your claim once it's been confirmed and approved. The individuals are one matter, but there's business entities as well. And there's a few specific things that you do want to keep in mind if you're going to be serving your claim on business entities. There's a database that the CCB has created for designated service agents for businesses. Now, if you're familiar, as a separate person, respondent, if the database, then you name first, but the designated, that can be done by mail, of course, but the designated service agent can also elect to accept claims by email, and that will be noted in the database. That's like particular steps that are required in the state that is relevant. There's also a concept of waiver of service, and you can ask the respondent to waive service by using a form that the CCB is going to provide, and that means that they've agreed to receive the claim without having been served according to the formal rules. Now, importantly, it does not mean that they've waived their right to opt out. Okay, this just means that they have waived formal service and are receiving the claim. The respondent can choose to waive service because doing so gives them an extra 30 days to respond to the claim after the proceeding has become active. All of this related to how the claimant serves the claim upon the respondent is going to be detailed in the materials that I think we're going to talk about a little bit later from the CCB.
All right, thanks, Tom. So let's talk about we filed the case now. We kind of notify the respondent about the case. What does the respondent do? The respondent has a decision to make, right? Do they opt out or do they participate in the case? So first off, I guess for Whitney is how does the claimant know who to serve?
Sure. So the claimant is going to serve depending on who the respondent is. So there's a couple, it's like a kind of a bit of a decision tree that the claimant has to go through. As Tom mentioned, when we clear the claim for service, we're going to provide a packet of materials for the claimant to provide to the respondent. You kind of, again, you make that decision about service sort of when you file your claim by identifying who the claimant is. If the respondent is an individual, the claimant will generally serve that individual. If the respondent is a business, the claimant should first check that designated service agent directory. This directory, it provides that eligible businesses can designate an agent. When they designate an agent, that's the way that you have to.
I want to stop here for a second. Young Black. So of that 300,000, 100,000 could be people who almost never go on YouTube. That's so true. Over time, you have people that subscribe and may not even, have their active account anymore. And actually YouTube does like every few years go through and they actually get rid of not active accounts. And you'll see like, whoa, how did, you know what I mean? Like you'll see like a drop, but seriously, that's so true. Good morning, Lori Jean. Good morning, everybody just coming in. And I think that's normal. People are still watching. Yeah. Hey, Giselle. The YouTube sweep. Yep, they do that every so often. Her video was hands down fair use. Yep, I agree. Oops. Damn it.
Hello, Hidden Gems. I am with a very special.
How did that happen?
Individual, the claimant will generally serve.
The portal. Hey, Cynthia. Hey, Tracy Burton. Have a good day. Drive safe.
That individual. If the respondent is a business, the claimant should first check that designated service agent directory. This directory, it provides that eligible businesses can designate an agent. When they designate an agent, that's the way that you have to serve. But there are advantages, right? A designated agent indicates that they can be served by mail and may also be served by email. That's an option. So a claimant who has a case against a respondent in the directory means that you will serve by mail.
Thank you, Giselle. Thank you for gifting 5. Jilly, Susie Maud, Horsewoman, Anastasia Beaverhosen, and Dirty Diana. Welcome to Cooterville. Thank you for gifting 5. I really appreciate it. Thank you, Giselle. Good to see you today.
And if the respondent is unknown, you have to take a step. If you don't know who your respondent is, your claim cannot go beyond compliance review. So if you don't know who your respondent is and the infringement involves online content, you might want to consider what's known as a 512H subpoena. This is a way to go to an online service provider to provide to get the identity of a potential infringer. Now, this is a process that is it's a bit involved. It involves the federal courts. We're going to have some set instructions available online to help claimants identify who the respondent is through this subpoena process. So really, we think of service as like a moment that happens when you have a process server or somebody, take these papers, deliver it to a respondent. But really, you're kind of thinking about service back when you file your claim and when you're considering who your respondent is, and you'll kind of give us some information related to serving your claim at that time.
Okay, thanks, Whitney. So I'm going to go back to Tom here to ask him if you're a respondent and you want to litigate the case. In other words, you don't want to opt out. What do you do?
Well, this one's pretty straightforward. If a respondent doesn't opt out, then the case proceeds. If you don't opt out of the proceeding, the case becomes active, and the CCB will then provide you additional materials, including a scheduling order, which is going to set forth the next steps. So very straightforward. If you receive a claim and you don't wish to opt out, then you will the proceeding is going to become active, and you're going to get more information, including.
Hey, Dirty Diana, welcome in.
So then we can go to David. So what happens if the opposite is true? If the respondent wants to opt out, what does the respondent do? Can they just pick up the phone and call the copyright office and say, hey, opt me out, or maybe just send an email to the copyright office? Or is there a more formal procedure for opting out?
It's not quite that easy, but it's almost that easy.
Okay, how do you opt out?
If you're served with initial notice of the claim, it will tell you about the CCB and how a proceeding works, and it will also tell you a little bit about the opt-out option, a little bit about the pros and cons, and most importantly, maybe not most importantly, but most importantly, response to the question, how you can opt out.
He's so excited. This guy is so excited.
Online, which is the recommended way. The notice will tell you exactly how to do that. You just have to fill in some very basic information. You have to find your case name and number on a list that will pop up. You have to file some basic information about yourself. You have to provide a particular key code that is going to be included with your initial notice, just so that when someone goes in to opt out of a claim, we're actually sure it's actually them because they got the key code. Not everyone else on Earth has it. You have to sign, which means really when you're doing it on a computer, you just have to type your name in on the signature line. That's a valid signature under the law, and you're done. You'll get an email confirmation almost instantaneously. That's why we recommend it. You can go on there online. You can do it right away. You'll get an instantaneous email response. Nothing could be easier. But you can also use a paper form that we're going to include with everything that's served on you. It asks for all the information that you're asked to do online. You simply fill that out, sign it, and send it back to us in the mail. That's all got to be done within the 90-day period. Which means you have to drop it in the mail or give it to like a FedEx or a carrier like that no later than 90 days after. And you're done.
He's very passionate about copyright.
By mail, I think of the paper opt-out. Is that right, Whitney? I'm trying to remember now whether we...
So what happens though after you opt out is what I'm trying to figure out here. If like kresha served and she says, nah, I want to opt out, I don't want to be a part of this, then what happens? Oh my God, me too. Kels, same.
We ended up with that.
Confirmation is generally by email. We do have some provisions in place when we know that people have restricted access to technology. So we do try to provide the quickest confirmation, but we do also recognize when people come in with limited access to technology. And so we have procedures in place for that as well.
All right, great. So Tom, going back to you, what happens if a respondent opts out within the deadline? What happens if they do not opt out?
There we go.
Yeah, so if you opt out, then the CCB will dismiss the claim against you. But of course, very importantly, the claimant can still bring that claim in federal court. That's part of the incentive.
Oh, okay. So if you opt out, if someone takes you to CCB court, then they can turn around and take you to federal copyright court. However, what is important to note about federal copyright court is that you have to have a federal copyright lawyer. And they aren't cheap. And not any old lawyer can do it. So if Lauren were to pull a federal copyright lawyer out of her hat, I would have to wonder who's paying him. You know what I'm saying? If she were to do that. But I don't think that she would. But hell, who knows who's backing her? You know? So like if you opt out of this, if you get a claim, and this goes to any creator because anybody can file these. So if you get a claim, you can opt out and then they can have the option to go to federal court.
To stay with the program. In addition to the notification that you get from the claimant, the CCB will send a separate notification if you've not yet opted out to make sure that you've received a copy of the claim and know what the opt-out period is and the other information that was discussed. And so as we discussed earlier, what happens if a respondent does not opt out? Well, very simply, the claim becomes active, because at that point, to get to the point where the respondent has received the claim, it's already been confirmed by the CCA, the attorney over there at the Copyright Claims Board.
All right. So we've talked a lot about opting out, not opting out. Let's talk a little bit about the decision-making process. Terica, maybe you can help us out here. Why would someone decide to opt out, or maybe decide not to opt out? Like what factors might go into that decision?
Yeah, sure. So, I'll take the question of why might someone decide to opt out first, and then why might someone not opt out? So someone might decide to opt out, frankly, because, maybe they feel like the claim that's being brought against them is a frivolous claim and doesn't have any basis. Or alternatively, they could opt out for any reason if they just don't want to participate in that particular case.
Okay. So if you think it's frivolous, you can opt out. And then the ball goes back into her court like it did when she countered.
They can choose to just opt out of that proceeding. But I think the question that many of the people in attendance today, and frankly, a lot of people that I've heard from that's the bigger question, is why would someone choose to participate in a process that's voluntary? Why would they not just opt out? I think the biggest reason why someone might choose to participate rather than opt out is because of the significant limited liability at the CCB as compared to federal court. So if someone, has a claim that's brought against them and they look into the circumstances and realize, hey, I actually did infringe this work, or, I didn't realize it at the time, but, I have violated that person's rights. The significance of limited liability at the CCB, which is maximum $30,000 compared to federal court where there are no limits at all. And then per claim of infringement, there's a $15,000 cap at the CCB compared to a federal court, which is $150,000. If you
see, that's what I was telling you. When I was sued in federal court, it was $150,000 per infringement. For the CCB, it's $15,000 per infringement. But that shit can add up too. But clearly, we saw on Lauren's filing here that she is not going for money. If you look here, it says, would you like to proceed as a smaller claims, including the $5,000 limit? She said yes. So she's not looking for money. She wants their opinions to disappear.
At the CCB compared to a federal court, which is $150,000. If you assess the facts of the situation and realize that you actually might be liable for what you're being accused of, it could make sense for you to actually choose to go before the CCB rather than take your chances of ending up in federal court. Not only is there limited liability, but the process is significantly simplified such that you can represent yourself, so you don't have to take on that additional cost of having to hire an attorney that you would likely need in federal court. We mentioned before that this process is entirely voluntary, both for the claimant and the respondent. And although it is very expensive to litigate a case in federal court, it doesn't mean that every person who has a claim and brings a claim to the CCB can't afford federal court. So again, because the process is so simplified, because there's such a cost savings, there likely will be people who choose to bring a case before the CCB who actually could afford to go to federal court, but due to the particular circumstances of this case, may choose to bring that case to the CCB. So just because you are a potential respondent who has a claim brought against you at the CCB doesn't mean that that person can't afford to go to federal court. And so I think it's important to kind of weigh out the claim that's being brought against you, weigh out your potential liability, and really think about the fact that this person could afford to go to federal court potentially. And if that is the case, you would be opening yourself up to significantly more liability than.
Yes. If you actually did infringe, you're better off going in front of the board. Now, no, she did not. You're right. She didn't want Kay's. She doesn't want Kay's voice out there. She doesn't want Kay's voice out there because it makes her look bad. This is all about cleanup. She's got herself tangled in a mess.
If you just go with the case in the CCB.
All right, thanks.
Yes, if it's frivolous, kresha can actually go at Lauren for damages. Okay, I think I said that right. Yes, she can seek damages.
Thanks, Terica. So we've talked about filing a case. We've talked about what the respondent does when they know they find out that there's a case against them. We have even talked about what the real big part of this, right? Which is what happens when you have an active proceeding. That's really the biggest part of this. And we're going to dive into that now. But before we do, we've got these kind of, like I said, speed dating questions, because we want to make sure you understand when we use terms, we want to make sure you understand what terms we're using here. So I'm going to call on Whitney here to talk a little bit about discovery. What is discovery? And in the process of discovery, there are terms like interrogatories, request for admissions.
What I want to know, we're not going to watch this whole thing, but I want to know if she has to provide a copy of the infringed content as well as the original. So I want to listen through that. And then I've got a sneak peek of the view across the street of the Boise incident.
Request for production of documents, very kind of legalese terms, perhaps. Maybe you can explain what those are, because we're going to talk a little bit about those. So
yeah, absolutely. So just to kind of orient us, we've got the claim, compliance, service. Now we're at that active proceeding. And as Thomas mentioned, we're going to issue that scheduling order. And the scheduling order sets forth what we're going to see in the active proceedings phase. And we kind of think about it, we have discovery, we have conferences, we have written testimony, we might have a hearing and a determination. Those are kind of the big chunks. But let's focus on sort of one of the technical terms, discovery. So discovery is the process of sharing information between parties about the evidence involved in the proceedings. This information includes documents, images, objects, or responses to formal questions. We have certain things, elements of discovery.
Okay, so maybe they wait for Kresha, if she's actually served, to then provide her side. I don't know.
Within a proceeding that allows people to exchange information in a structured way. So know that when parties are in an active proceeding, we'll be giving standard forms, standard questions, standard requests to both of the parties to kind of take the mystery and some of the complexity out of this discovery or information sharing process. So just to highlight some of the technical terms that you might hear, there's interrogatories. These are formal questions that asks the other party about information related to the proceedings. This is the who, the what, where, when, and why of a particular proceeding. The second thing is a request for admission. This plays a big role in federal courts. This is asking the other side to admit a certain fact or point or position. In the CCB, this is very limited. We only allow them when the parties really need them. But the other big part, so we have interrogatories, which is a term that you'll hear when you're involved with a CCB proceeding. But then the request for production of documents. This is a standard list of asking the other side, hello, I need any document that you're going to rely on, ones that you find important to your case and ones that might be important to mine. Again, when we're thinking about these terms, you're not going to be alone. We are going to be giving you standard lists, standard explanations, and we're going to make sure that we have conferences at the beginning of this process to make sure that everyone understands some of these terms that I just talked about.
Okay, thanks, Whitney. David, so let's say the window is passed, the respondent has not opted out. What happens next?
Well, what happens next is first the claimant has to pay the remainder of the filing fee. Thomas alluded to the fact that we have a two-tiered filing fee. That was something we did after we got a lot of pushback to our initial notice proposed rulemaking. So the filing fee remains at $100, but it's just $40 upfront. If the respondent does not opt out, in other words, if you have an active proceeding, then you have to pay the balance of that $100 fee, the additional $60. So that's the next step. We don't go forward till we have the second installment, shall we say, on the filing fee. Once that happens, then all parties who have not yet registered for the ECCB, our Electronic Copyright Claims Board, our online filing system, will have to register, because almost all papers are filed and served through the ECCB. I mean, one of the wonderful things about the ECCB is, unlike in federal court where you have to serve papers on parties, although I guess maybe with PACER that's not necessarily the case anymore, but in any event, everything basically is served by us. You file it with us, it gets served on the other parties. And once that happens, there will be a scheduling order issued, and I think Whitney mentioned that, and I think Tom maybe even mentioned earlier as well, which will have deadlines for all the major steps in the case. And the first deadline is going to be for the respondent to file a response to the claim. We talked a lot about the claim.
Okay, so this is where if Kresha were to be served, if she opts in to participate, she would then file her response. Let's listen to how this goes.
We've also got a response. For those of you who know what federal court works like, it's the same thing as the answer, just like the claim is the same thing as the complaint in federal court. So it's where you have a chance to admit or deny what the claimant alleges, and to say why you think, assuming you do think, and you probably do or you wouldn't be filing it, why you think the claimant shouldn't win, assert any defenses you may have, and so forth.
Okay, so Erica, I'm going to have you pick up the ball from there. So after the scheduling order is issued, the respondent then has a chance to respond to the claim. How much time does the respondent have to file the response? And how might the respondent respond?
Yeah, so the deadline as far as when the response is due will actually be set by the scheduling order that will be issued by the CCD. So it's important to pay attention to the dates and deadlines that are articulated there. And as far as how might they respond, one way that they can respond is to assert different defenses to the claim that's being brought against them. So a respondent can raise any of the defenses available under the Copyright Act. So one of the most known of those defenses is fair use. They can bring a fair use defense or any other defense under the Copyright Act, as well as any other defense available under the law. So for example, they might raise a defense about the statute of limitations. I know Tom touched on that earlier. In addition, they can raise counterclaims in response to the claim that's brought against them.
Counterclaims. So she can not only respond, she can counterclaim. Thank you for gifting 5. Let's welcome in our new Cooters, Critical True Crime, Ronnie, Yaya, Michelle Gallegos, and Kindness and Grace. Like your name. It's nice to have kindness and grace. Welcome to Cooterville. And thank you again, Pines.
But the counterclaim must be related to the claim, the initial claim, in one of 2 ways. It must either be an infringement claim or a claim of misrepresentation under Section 512F and arise under the same
There we go, 512F.
Event or set of circumstances that gave rise to the original claim. Or if the original claim is itself a copyright infringement claim, the respondent can bring a counterclaim related to some sort of contract or agreement pertaining to that infringement claim. So those are 2 of the ways that a respondent can respond to a claim against them.
Yeah, your membership came from Pines.
Thanks, Erica. So once the respondent responds, the claimant then has an opportunity, perhaps, to respond to any counterclaims by the respondent. So we're not going to get into too much detail there, but then we jump into discovery. And you already talked quite a bit about this, right? Discovery can be pretty elaborate and pretty complex in federal court, certainly. Can you?
Okay, so we're going to talk about discovery, which means any videos, pictures, documents, whatever they're going to admit into the case. And I know you guys are all saying like Kresha needs a fund. We totally need to ask Kresha. Purple, we love having you here. 512F, don't forget that. Yes, she did use fair use, 100%.
To discuss a little bit, maybe to touch, I don't know if there's anything else you want to touch upon that you haven't already, to discuss the discovery process at the CCB and how it differs from discovery in federal court. You've already touched a little bit upon this. Maybe there's something you want to add here.
Sure. So, I actually saw a question in the chat about depositions. And this is actually a good point to make about discovery between the federal court and the CCB, is that there are just some elements that's contained in the federal court that are complex, exhausting, and costly. That just won't be with the CCB. And one of the main things that we will not be having is depositions. So depositions, as I mentioned, requests for admissions are limited to cases where they're really needed. It's the same thing with expert witnesses. We are going to be weighing very carefully when parties ask for expert witnesses.
Lord, could you imagine Lauren's expert witness, John?
Requests very, very carefully. So when we're looking at discovery and we're comparing it to federal court, we're looking at a little bit more of handholding and involvement from the CCB. So, federal court discovery is handled mainly by the parties outside of the view of the court, handling the CCB discovery process, not just with the beginning conferences before the discovery period begins, but also with those standard sets of interrogatories and request of documents, means that the process is not is much more circumscribed throughout the CCB proceeding. And I'll also note, we've talked about sort of the main track for a CCB proceeding, but the office will also provide a smaller claims track. So this is for, or what's sometimes known as microclaims. So for people with a certain level of damages, they can select a smaller claims proceeding, which is even more stripped down than a main small.
Okay, this is what Lauren chose, the smaller claims proceeding. So listen up. This is applying to what Lauren filed.
Claims proceeding. And in a smaller claims proceeding, we're not even looking at sort of a standard discovery process. We're looking at an initial conference with the CCB officer, and the CCB officer really discusses with the parties what information is actually needed for each party to sort of make their case before the CCB. From that, the officer will provide further direction about discovery, but there it's really more narrowly tailoring discovery to just the elements that are needed for the proceeding. So that's really the big difference between federal courts and smaller claim and the CCB is that it's less complex it is more standardized. And with the smaller claims proceeding, it even has the opportunity to be more narrowly tailored to the proceeding at hand.
All right. David, Whitney talked a lot about discovery and you touched upon and others touched upon the scheduling order, and there are deadlines in there, right? And so what happens if a party misses a deadline? Is the case dismissed? And for that matter, just aside from deadlines, can the case be dismissed for other reasons beyond just missing deadlines?
Yes. Well, those of you who have had the pleasure of being in federal court know that deadlines are very important, and you definitely don't want to miss a deadline. It can mean the end of the case for you, depending on what the deadline is and how you deal with it.
I'm sure they're more lenient. Okay, so that gives us the basis, the background, okay? Whew, that was a lot of information, but we need to know, right? We need to know what the hell is going on here. So now we're going to go and we're going to look at this, okay? Oops, let's go back. This is Sleuthie Goosey on X. And she posted after Kresha announced that she was being taken into litigation over this copyright business. And Sleuthie says, I had no idea that Sleuthie was also hit by Lauren. For those asking about Lauren Matthias's previous copyright strike on me, here you go. Seems like she basically just copy-pastes the same thing for everyone, including Kresha. My 2 lives were like 4 hours each, and we covered an hour-and-a-half interview over the course of 8 hours. So that was like what happened to me. I covered like 8 to 10 hour streams sometimes during the Brian Laundrie manhunt. Not all of my streams were WFLA. However, in federal copyright court, I would have had to get an attorney at $500 an hour to review those 10 8-hour streams. I would already be in the hole. That's not even, part of a defense. That's just for him to review to see if I even had a case to fight. So I can see why they brought this smaller claims type thing, right? This got dismissed, by the way. See? Fair use. So Kresha's may get dismissed. She may never even get served. But it's the principle of it. She put, LOL, I put a shitload of work so that other people can use it, and I'd never copyright strike someone for using it or criticizing it. Didn't she say in her 9-hour live that we can criticize her work all we want? Another lie. So if we look here, let's blow this up. Same thing. Has the work been registered? No. Motion, picture, and audio visual describe the work. Audio, video, interview entirely produced by Lauren Matthias, Hidden True Crime. Describe the infringement. Blank, also known as Sleuthie Goosey on YouTube, played our entire video on her YouTube channel over 2 separate live streams. She took our content, which we wrote, directed, and produced entirely on our own from our YouTube channel, Hidden True Crime, and then played it on her own channel so that viewers would watch her channel instead of ours. She was also encouraging hatred by filing her live stream of our work, Pig Roast, and oh my God. Her live stream was called Pig Roast and spouting harmful and false narratives, which again is not part of copyright, about Hidden True Crime and the subject of the interview video. This led to many online narratives and posts being created about Hidden True Crime. It's the same shit. All right, let's go to the next page. Okay, this is just blown up. Okay, we've read that. Wrongful activities publicly perform the work. Is the infringement ongoing? No. Okay, so here it is where you can see it. Oh, Pig Roast. Yes. There's where you can see it bigger. Pig Roast. I've seen so many people call Dr. John the movie Babe. Dr. Babe. This led, okay, I already read that. The relief we are seeking is that the streams of our video interview not be posted on the internet again. So here she has attached the original infringing video, the original thumbnail, image showing viewers watching on Sleuthie Goosey versus Hidden True Crime, who owns the interview. The response from YouTube showing second video removed per copyright, and the response from YouTube showing first video removed from copyright. There you go. There's pretty much the same thing. I love that. The pig roast. That's pretty much all of it, guys. That is pretty much all of it. Hold on a second. Let me get this video pulled up. I want to show you guys the other view that I got because I haven't been able to put what I want to do for the Boise incident is I want to put them side by side. So that's what I'm going to do. So let me pull this up and I'll show you what the video looks like. We'll walk through it and then I'll just play it if you guys want to like screen record it or whatever. Hold on. I think it uploaded as a short. There it is. And like I said, remember Lauren was filming at the same time. Hold on. Let's get this pulled up here. Lauren was filming at the same time from her direction. So I think it's going to be interesting to have Lauren's view and this view next to each other so that we can walk through it. But here, that's... So this is when they came up to Lauren's and said, why are you talking to her? You have, you filed a cease and desist. Like, why are you still talking to her? Type thing.
Oh, she's telling Grayson to calm down. We should go so you can hear.
Yeah, no, she did not receive an award. She went to an awards show where victims were getting awards for being crime fighters. There, I'll make it a little bit bigger. Now, this is the view zoomed in from across the street where they were having their dessert. And no, she was not a speaker. So those are two of the girls. Remember, Christina was accused of being the stalker at this incident, and she was in Europe. Okay? Christina was on vacation. These are the other girls, the friends of Christina. And we're going to go over this in depth with both views. The very end is the best. She seems like she's really scared for her life. Remember, she called for 911 for an escort after this.
Seriously, she's gonna twist that shit out of her.
This is when she sees they got their phone up. Can you change the speed on shorts? You can't. Darn it. You did another pig roast on your channel to see if she'd strike you? Did she? She didn't strike you, did she, Critical? Right. This is, and then she calls 911 for an escort to the car. Like, come on, lady. Come on, lady. Wait, we need a soundbite for this screen grab.
The lawn crime.
She's unbelievable. Christina wasn't even here. And then the Boise incident is actually blamed on Christina, right? Oh, it's just nuts. I've got one more screen grab here. Hold on. There's one more person that was affected by Lauren, and I don't want to miss this. Hang on a second. I think this might be you, Crimes. Emily? This is Emily. She says, hold on. Let's make it bigger. This was posted November 17th. It says, is saying, fuck you, Lauren Matthias, harassment. I shared Kresha's video as a post on YouTube with that caption on my YouTube page, and it got removed. So it says, your post didn't follow community guidelines. We removed it. And it looks like she got a community guidelines warning for that because she shared Kresha's video as a post on YouTube and said, fuck you, Lauren Matthias. That's you, Critical True Crime. Yes, yes. Okay. I had that saved as well. So that's the third one. That's the third person is Critical True Crime with Emily. I'm glad it was just a warning, though, and not a strike against your channel. That's pretty crazy. Did you guys see Lauren on Web Sleuth the other day? Put a 1 in chat if you watched that. Funny, we haven't heard from Grayson lately. She was pretty quiet in the Web Sleuth, even though Tricia's her buddy, right? Mm-hmm. It could be anybody. Janice, you did? Let me check my email. Let me check the email. But yeah, that's what I'm going to do with this is I'm going to put them side by side so we can see both views. Let me see what Ballet Flats sent me. What is it? Is it going to get me sued by Walwyn? I don't see anything from you. When did you send it, Janice? I don't see anything. Did you guys think that she talked weird on the Web Sleuth? You can't stand to watch her anymore? Oh, she struck Joe Schmo too. That's right. That's right. I'll keep this up if Janice wants to resend that. I'll keep my email pulled up so I can check it right quick. But here, I'll play this in its entirety.
She's going to twist that shit out of it.
The music better make a documentary about this.
Oh, she's telling Grayson to calm down.
Before Delphi, she struck Joe. As far as I know. Or was he hit after that? I thought he deleted his live.
You should go so you can hear.
She put her hand. Look at Lauren's hands. Watch. Her hands. Look at her hands. As is like Grayson with her porridge. That was so funny. Grayson with her hands over her porridge. I'm trying to eat a dinner and they're stalking me.
She's gonna twist
the
that.
end of it. I don't know why I find that to be so fucking petty. Oh my gosh. Jolene is hysterical. I found Jolene, I think yesterday. Hey, Andy. Good to see you, girl. No, she struck Joe before Delphi. She's taunting them like, oh, you got your phone up, so can I watch.
You should help me, Sarah. She's gonna twist that. You should help me, Sarah.
She's so petty. It does. Christina is, I mean, if she didn't wear those glasses, the move of wearing those glasses is just phenomenal. She also struck defense diaries for the Delphi case. Are you kidding? Wow. Yeah, I mean, it's a great screen grab. Let me see. I wish I could slow it down, but I can't. When I make the video and upload it as a regular video side by side, we'll be able to pause it. Jay, we need a soundbite of Turtle Boy. Money be green. If you send it to me, I'll add it. Her face. Lauren.
Sarah's
she's
gonna twist that shit out of it.
She like opens her mouth.
Sarah's
I can't catch it. It happens too fast. There we go. There we go. I got it. I know, Brenda. That part is what's really sad. Oh, Grayson had Zoom court against the DoorDash. Did you know that Grayson got in a little fender bender with a DoorDash driver? And that's why she's suing.
For making it happen. I want to say thank you.
Thank you, Idiot Wind. That part where she was taunting, it was where she claimed everywhere she waved. Can we see reenactment of the wave from her live? Where did she wave? I don't remember that. Let me see if I can pull up that other one. Hold on. I think I've got him on my other channel. Speaking of my other channel, if you're not subscribed to J is for Justice, the mods can put the link in there. But we cover true crime, trials, stuff like that. All right, let me see here. Let's get Lauren.
The lawn crime.
Okay, I think I got it here. This will be there. So let's just roll through these for just a minute here. Hold on.
And Aurora, like, just because.
But
I know that she's gonna have me arrested no matter what.
Well, and I'm trying to avoid.
Yeah, no, I know. So
I want you to come out here.
Oh wait, that's not it.
I don't know the full story.
That's the bar videos. I don't know if I have the other videos. Do I? The Boise incident. Here it is. Here it is. Hold on. Let me fix my screen. Matthias continued her unusual and concerning conduct in two main episodes that occurred on July 23rd, 2025. On July 23rd, I attended a press conference along with H and S, which is Lindsay and Janice, I think. H and I were saving a seat for S. Shout out to Lindsay and Janice. Holla. when Matthias and Grayson entered the venue. Matthias tried multiple times to get H's attention to ask if she could sit in the seat we were saving. Now, who does that? Who sends a cease and desist and then wants to sit next to them?
Walwyn.
Get out of here.
On prime
I saw
crime.
H appear extremely uncomfortable as she tried to avoid contact with Matthias, eventually putting her hand up and turning away. At that point, I briefly spoke to Matthias and told her that I did not feel that it was appropriate for Matthias to sit or speak or sit by H given the cease and desist. Here we go.
Recording me, so I did what you did. I just waved, and then she proved she was, but I just flipped me off as I waved. I'm I don't know what. Don't stare. Don't stare. I do. Remember what we decided. Please do not give them air.
About today?
What?
About today? You sent her a cease and desist. You had the cops call Christina about stuff that you shouldn't be waving at her. You shouldn't be talking to her. You should be staying far away from her.
So the cops have nothing to do with what
I'm just saying, don't.
I was asking about a seat. I was asking about a seat. I walked away.
You said Lindsay. You said Lindsay. Lindsay. Is anyone sitting here? Don't talk to her.
Lindsay's in her 30s. She
Don't talk to her.
Lindsay's in her 30s. So this is what was going on. I'm going to put both of these up. F it. Because we have a little bit of time. We're going to put these side by side right here in this stream. Right meow. Cram it. Taking volunteers and a crash course on all this. Eyeballs. Oh, shit. Thank you for your super chat, Cram. Okay, let's get the other. Hang on. We're going to get this one up. Just because you have to have the full effect. I don't feel right not giving the full effect. Shit. Okay. Now let me shrink this one down. We'll get this all set up for the grand finale. Okay. We're going to mute this one.
I'm not talking to you.
Lindsay doesn't want to talk to her. She sent her a cease and desist letter. Why would Lindsay talk to her?
The cease and desist is letter to Christina, and the police calling Christina. I didn't request that.
I can't hear
someone,
you.
Just stay away.
Someone that
Stay away. Just stop acting like nothing happened, that you haven't done anything.
I haven't done anything, and I will stand by that forever. Yeah, it has nothing to do with you guys. It has nothing to do with
We
this.
are her friends, and we will back her up till the day
A cease and
she dies.
desist is a legal business. It has nothing to do with you guys.
Things that you did.
What did I do?
You accused her of things you did.
What did I do?
You sent her a cease and desist, and then
What
you
did I
approached
do?
her. You approached her after you
A
sent
cease
her
and
a cease and
desist?
Why would you want to approach her after you sent her a cease and desist?
I asked if I could
I know.
sit.
I told her there wasn't.
I was at a press conference.
Well, then she kept asking. I know. What does that have to do with anything?
When there's not a lot of seats, you say
There were lots of empty seats she could have sat at, but she chose to ask about sitting. She chose to specifically approach somebody by name that she sent a cease and desist to. It's just like,
Great. Guess what? You know what? I work with Lindsay, and she tried to get me sued. So guess what? I don't give a fuck.
I don't know you.
Well, you know me. You don't know
No,
me.
I have your phone number because I wanted to get eyelash extensions, but we've never hung out.
No,
I don't know you. So could you please get away from our table because you're making me uncomfortable. I don't know you. I don't know why you guys approached us. We asked about a seat at a press conference. I don't approach you guys when we're all hanging out together.
We don't all hang out together.
You guys, I know. So you're approaching me while I'm trying to have dinner. I approached you at a press conference about a seat. Could you please? She's bothering us. Could you tell her to leave us alone? I don't know her. I've never communicated with her.
All right, Hoochie, I don't know why that's not up yet,
Thank
but
you.
at least they got the mic out.
At that point, Matthias and Grayson crossed to the other side of the venue and easily found a seat, which made it obvious there was no reason for Matthias to try to engage with H. Then, for no apparent reason, Matthias sent Grayson back across to our side of the venue. Grayson came and stood right next to me and my group, including H, who were seated. Later that night, I went with H, S, and others to H's favorite restaurant in Boise. Now, mind you, Christina was not even here. Christina was nowhere in Idaho for this. We dined for and they wanted her to wear a tether and go to jail. She wasn't even there. That is wild to me. Even Dr. John's declaration said he wanted criminal charges on Christina. Hey, law and crime.
The law and crime.
We dined for approximately 2 hours before leaving to go to dessert at a different restaurant across the street. How dare they want carrot cake? As our party was leaving, we learned that Grayson and Lauren had arrived at the restaurant and positioned themselves in the outside dining area near the exit.
Literally, poor people get murdered. Like, you don't respond.
Where are they?
They're literally across the street from us waiting on us to leave this restaurant. 3 of them left, and the only ones left are Lori, Janice, and Lindsay, which means the 3 of them are waiting to confront us.
So the 3 that have always confronted us.
They're all waiting.
Her face. Grayson's tanked. Look at all those lemon shot drinks in front of them. Tanked.
What's next? Do they physically assault me? Because I don't respond to them?
S exited the restaurant before I did and texted us that Lauren and Grayson were outside. Even with this knowledge, there was no way for us to exit the restaurant without passing right by Lauren and Grayson. Westy, are you serious?
I'm literally at dinner, enjoying a dinner, and they're coming up to me and making me feel unsafe when I'm...
This is Grayson and her porridge. I'm literally at dinner.
Not doing anything, and I'm telling them to leave me alone. Like, I'm not even, like, doing anything. It would be one thing if I was going up to them. But
now, Janice, who's in chat, she is the one who was confronted at the courthouse in Arizona. Remember when she walked up and said, "Are you recording me?" That's Janice. Everybody say hello to Janice.
that's what I stay away. All they do everywhere in public is film me.
No, I know. They film you ever. We just do our work.
So what? Because we didn't answer the filming, now they confront us? What's next? This is when people get murdered. We're in this. We see this.
Oh my God. This is when people get murdered.
This is when people get murdered. We're in this. We see this.
As we left, I again spoke briefly to Matthias and expressed my view that it was inappropriate for her to continue to try to contact or provoke an encounter with H, given the cease and desist. We then crossed the street for dessert as previously planned. At no point did we attempt to further engage with Matthias. Nevertheless, Matthias called the police and accused us of stalking her. I spoke to an officer explained the situation, and the investigation is now closed. Christina was not with us during either of these incidents in Boise and was, in fact, out of the country. Christina did not suggest, ask, or otherwise prompt us to interact with Matthias. Christina was in Europe. And that's it. And there we go. Megan Connor. Good to see you, Purple Ivy. I hope you're having a good day so far. We went live pretty early this morning. But that is all I have for you guys today. I hope you guys enjoyed the stream. Let me come back and bid y'all farewell. We're going to be going over, I don't know. I'll put together a video of that side by side, though. That was pretty good. But tomorrow, I think we might go over Lauren Then and Now. I found some interesting stuff about her Mormonism or not Mormonism. There's some things that I wanted to go over with you guys. And last but not least, I want to say thank you for being here. If you haven't hit the like button, now would be a great time to do so. Cram it, close your legs. You can close them after we get, or you can open them back up after we get in the Cooter DeVille.
A Cooter DeVille. I think the devil drives a Cooter DeVille. I saw the dreadlocks over the hill. Not against her will. I got time to kill way down in Cootersville. Okay.
And join me tonight. I'm going to be live on J for Justice at about 8 p.m. tonight. We're going to be going over the Friends of the Idaho 4, their interviews. I haven't seen those yet, so hopefully you'll join me for that. Actually, I can probably set up a redirect really quick if I'm fast about it. Welcome all the new Cooters. If you know, you know. Look at your name on the board. Let me see here. I can set you guys up over there. You can hit the reminder. And carrot, how dare they want carrot cake? If you're if you're not busy tonight, join me over there. We're going to walk through those interviews. And I think that's pretty much it for that case. As far as anything coming out, the Gonsalves family are suing WSU, which I have that lawsuit too. I think we might go over that soon as well. But if you guys hold on a second, I am going to set this up and redirect. Hopefully I'll see you guys later. But definitely I'll see you guys tomorrow morning for more Hidden True Crime. Think you guys will find interesting what I've found. Let's see. And if Kresha replays this, we got your back, girl. We know you did fair use. And we'll support you, whatever you need. All right, guys. Well, thank you so much. I'll see you guys later. If not, I'll see you guys in the morning. Thank you for your support. Bye. Enjoy the rest of your day. It's only 11 a.m. on the East Coast.